Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have one case on the docket today, Sheriff Morris Young versus the State of Florida. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. May it please the court and counsel, my name is Luke Newman. I represent the petitioner in this matter, Sheriff Morris Young. I would like to reserve 3 minutes of my time for rebuttal.
You may.
Your Honors, Florida contempt law, including the decisions of this court and other district courts, preclude the state from going forward with the prosecution in this matter. I want to be clear that the state has chosen to proceed in this controversy using the vehicle of indirect criminal contempt. With that choice come the limitations that are inherent in contempt proceedings based on Florida law. The main limitation that I want to talk to you about this afternoon is that a criminal contempt, indirect criminal contempt prosecution requires a violation of a clear and definite court order. We're talking about a court order which commands or prescribes a specific behavior.
Well, counsel, if I could ask a question here. You don't contest that the state attorney can bring this type of proceeding to, in a petition, say, here's the clear court order, here's the sheriff's conduct, which intentionally violates that order. I ask the court to hold him in contempt. That's permissible, right?
I would agree, Your Honor, if there was a clear and definite court order.
Okay, well, as I read the trial court's order, he's already found, he said it's indisputable that there's a court order here.
What the trial court found in his order that it was entered after a motion to dismiss, that it would strain credulity to find that the sheriff did not know about the existence of a first appearance.
I'm sorry to interrupt, but if this case goes forward, what's left? If the trial judge has held there's a clear order, it strains credulity that the sheriff could not have known about it, what's left in this proceeding?
I would submit to you, Judge, that what the trial court was mistaken in making a ruling that relied on the existence of a court order. There certainly is a court order. When the court orders in first appearance matter, the court enters bond conditions and amounts, that's certainly a court order. So there is a court order. What there is not is what Florida contempt law requires, which is a court order which prohibits specifically, explicitly, certain conduct. And that court order simply doesn't exist.
Are you suggesting that orders entered after first appearances by judges setting bond should require that the sheriff may not issue furlough? I mean, does it need to be explicit?
I would submit to you, Your Honor, that it does. That it needs to be explicit in the context of then later on using that court order as a basis or an attempted basis for criminal sanctions.
Isn't it implicit, though, in that the sheriff doesn't have explicit authority to grant furlough? Isn't that correct?
Well, there's a dispute about that, Your Honor, and I would submit to you that it's been argued at the lower court below, but that is disputed. And that I'll point out to you, Judge, that the practice of issuing furloughs to people incarcerated in the county jail is a practice that was undertaken by the sheriff prior, who sat in the seat prior to my client. It's a practice undertaken by the Department of Corrections, which incarcerates people who are sentenced to do prison time pursuant to a 9 or 10 or 11-page written order.
But we're not asking about the Department of Corrections authority. We're asking about the sheriff's authority explicitly to grant furlough. And where can that be found in the statutes? Any rule? Can you point to that?
I'll address the statutes right now. And before addressing the statutes, Your Honor, I'd like to point out that I think it's important that we look at statutes. But when we look at the statutes, I'd just like to point out ahead of time that statutory violations are not a matter that gets addressed in a contempt proceeding. The indirect criminal contempt is intended for a circuit court or a lower court to enforce its own orders. But I'd like to go back to the statutory question because it was asked. And at the hearing below, my client relied on Section 950.001, which deals with regional jail facilities, and that statute directs the operators of a regional jail facility to promulgate rules consistent with DOC regulations. DOC regulations allow for not one, but 2 different furlough programs, neither of which require judicial pre-authorization. Additionally, in the pleadings that have been filed in this court, the statute 951.23 has been raised. 951.23 has been interpreted by the Office of the Attorney General as delegating to the sheriff all authority regarding decisions of the internal operation of the county jail, subject to the applicable rules and regulations promulgated by the Department of Corrections.
Well, even assuming, okay, that there is authority here on the part of the sheriff to administer a furlough program. When we're talking about situations in which an order has been entered after first appearance, the order, correct me if I'm wrong, specifically sets out the circumstances under which that individual can be turned out of jail, correct?
That's correct, ma'am. Yes, ma'am.
The action that the sheriff has taken or asserts that he has the authority to take here, does that not essentially nullify the court's order?
I want to address that, but before I address the question itself, I want to say specifically that, well, I'll just address the question. The first thing I would point out to you, Judge, is that the sheriff is not a party to that action.
Well, to whom is the order directed?
Well, I would submit it's directed to the defendant. It creates.
How could it be directed to the defendant if the sheriff is the officer taking that individual into custody?
Well, I would say it would be directed to the defendant because it provides the defendant with actions that he must undertake in order to obtain pretrial release. So there's usually a bond amount and some other specific pretrial release conditions that are addressed in a first appearance order. From that point, and I wrote this in the pleadings that have been filed herein, from that point, the defendant, if he cannot or will not make those bond conditions and obtain pretrial release, he's remanded to the county jail, the jail facility. This court has previously held the operation of that facility and the control and custody of the inmates therein incarcerated are in the hands of the sheriff.
Well, that's true, but in this particular situation where the individual has gone through first appearance and a written order is issued specifying the circumstances under which that individual can obtain release from jail, is that person still not under the jurisdiction of the court?
Absolutely, the defendant.
So the action taken by the sheriff here interferes with the jurisdiction of the court over that individual. Is that not a problem?
I would agree that there are aspects of the facts alleged below that I have to accept as true for our purposes today that would cause concern.
And I guess when, we all have these different concerns here about what has occurred, what your client is ultimately arguing is that under the stated facts, taken as true, that there is no possible way that contempt lies here. And I'm not sure it's as clear as all that.
I would respond to that by saying that contempt can only lie if the court is relying on a prohibited clear court order. An applied, assumed, or inherent provision of that court order is insufficient to support an indirect criminal contempt prosecution.
So what you're asking us to conclude is that absent some provision in the order issued after first appearance that says, and Sheriff so-and-so, you may not release this individual under any furlough program, that those orders have to state that, notwithstanding the fact that the court still actually has jurisdiction over the individual.
I'm not arguing that that would be required in every individual first appearance case, Your Honor. What I would say is that this contempt action, the one that we're arguing about at bar this afternoon, it was brought without ever obtaining any court order ahead of time, whether it be through a civil contempt or any other kind of court order that could be violated. And that we're in that position because the state has chosen to use indirect criminal contempt as a prosecution vehicle without having first obtained a court order which prescribes the conduct at issue.
Well, counsel, some of the orders after first appearance in the record are directly entered to the sheriff and to the sheriff's attention. And in those cases, isn't that an order directly directing the sheriff not to release an inmate expressed except for the conditions under which the bail has been set? So if the court has ordered, there's no release except for these conditions, and that's directed to the sheriff, isn't that the type of order for which contempt would lie?
I believe you're referring to an order in a child support matter. One of the cases below was a child support matter, and there is an order in our record in which the child support judge remanded in a contempt case for failure to pay child support a defendant to the county jail. And what I would say is that was similar to the first appearance order. I don't see a difference in that order. And I went back carefully and examined the language of that order, and I believe it's in the response appendix G, as in golf. I examined carefully the language in that order, and I didn't see any difference in that order in your standard criminal first appearance order that would be entered the morning after an arrest.
Counsel, my concern is you didn't give me any pushback on my characterization of the trial court's order that he has already determined that it's strange credulity, those are his words, that there were orders here and that the sheriff should have known about them. But now I hear you saying that it's only the face of the complaint. What's the posture of this case? Are you conceding the judge's order that there's already been a clear legal duty established and the sheriff, strange credulity, that he wouldn't know about it? I'm not sure.
I would respond to that by saying that the order on the motion dismissed that was entered below, what it does is it does not address my response to that would be that order fails to address the argument that was made below, which is that there is no clear court order entered prescribing or commanding any conduct on behalf of Sheriff Young, as it is relevant to this case. So when the judge below entered an order on the motion to dismiss, saying that it would strain credulity to believe that the sheriff was unaware of a first appearance order, I tend to agree with that. I think the sheriff was aware of first appearance orders. I think everybody in law enforcement is aware of first appearance orders. So that's not the argument. The argument is not that he's not aware of it. The argument is that that order is nonspecific. It doesn't prohibit, it doesn't command any specific conduct. And then if later on a party wants to proceed under an indirect criminal contempt basis, then that's a legal requirement. It's a legal requirement in the same vein as it would be in your more normal statutory prosecution basis, where the law has to prohibit something before a prosecution is brought. And we simply don't have that here.
One thing I gleaned from the record is there seems to be this tension between sheriff in Gadsden County and the circuit judges, because I was reading Judge Sheffield's testimony, and he said that the prevailing sentiment among the judges here, this is his quote, is we don't grant furloughs because people forget and don't come back.
Yes, sir.
So there seems to be a tension between perhaps if everyone worked together, there could be some give and take here. It sounds like, at least just from the record, that there's entrenchment, we don't give furloughs ever, versus we give furloughs sometimes in Gadsden County, and this isn't release, this is furlough.
Yes, sir.
Some leading to some unfortunate consequences. What's going on between these two principles?
I read that portion of the transcript, Your Honor, as a general statement by a circuit court judge that he generally won't grant a furlough, which is often requested between the time of a plea and the time of the sentence. And in a more normal statutory criminal prosecution context, that has led to a lot of litigation and a lot of sentencing issues. And so that's how I read that. But I think, we're talking about Judge Sheffield's testimony. I think it's important that we talk about. He said he only had one conversation with Sheriff Young. It happened after the fact in a child support matter. That's not one of the cases that's before the court.
And the sheriff complied.
Well, it was after the fact. Correct.
Judge Sheffield met with the sheriff. They talked it through. From that point forward, the sheriff was totally in synchronization with what the circuit judge wanted.
Correct. And then going and building on that a little bit, Your Honor, Judge Sheffield's testimony indicated that he told him this was in my cases, and I read that as being as opposed to another judge's cases. He also brought to the forefront the fact that my client had worked with another sitting circuit court judge in order to relieve overcrowding issues at the jail. I will reserve the remainder of my time for rebuttal. Thank you.
Thank you, counsel.
Good afternoon. May it please the court, my name is Matthew Pavis. I represent the state of Florida. When a judge says a person is not to be released from jail unless certain conditions are met, and the jailer releases that person from jail before those conditions have been met, that is the violation of a court order. Judge Marstiller, this goes to exactly what you were asking petitioner in this case is, how are these bond orders not court orders regarding the terms and conditions for release? That's really what they are in this case. These orders are directives at the jailer explaining the conditions upon which an inmate may be released. Absent meeting these conditions, the sheriff does not have the authority to override these conditions for release and determine who gets released and who doesn't.
Well, what the sheriff is arguing is that for purposes of finding him in indirect criminal contempt, that these orders need to be more specific, apparently.
Yeah, and that, let's talk about how specific these orders would have to be. In this case, he's asking that they would outline, and this is as Judge Rowe had mentioned, that Sheriff Young, don't furlough this inmate. And then what if Sheriff Young comes up with another scenario where he creates a rehabilitative program? So now the court's tasked with writing, Sheriff Young, don't furlough this inmate, don't enter him into your rehabilitative program. And then there could be another one that comes up. And ultimately, what the court's going to decide to do is say the easiest remedy for this is to say, Sheriff, don't release this person unless certain conditions are met. And that's what a bond order is. It's telling the jailer, don't release this person unless certain conditions are met.
Why can't the circuit issue an administrative order? It says, under the authority of our Article 5 powers, when we issue these orders, no sheriff shall release temporarily on furlough any inmate absent specific court order.
That
Why
could be,
hasn't the judiciary done that?
Your Honor, it has not happened in this case, and it's something that maybe the judiciary could do. However, that still doesn't work around the fact that when the judge has issued a bond setting terms for release, or there's a judgment and sentencing an inmate to incarceration, that Sheriff Young has the authority otherwise to disregard these clear court orders. Because we have these bonds and judgment and sentences, and in particular the civil contempt hearing in Mr. Hall's case, or the civil contempt order, these orders already dictate that he can't do this. The court would.
Okay, well, but I agree that if there's an order and it says this can't be done, so forth, and he violates it, then that's problematic. But we're here on indirect criminal contempt, beyond a reasonable doubt, clear legal duty, intentional conduct, willful conduct by the sheriff. Isn't that your burden?
Your Honor, on a direct appeal, intentional conduct would be something we would probably want to address. But because we're here today on a petition for writ of prohibition, the question's a little bit different. It's, did these orders, writ of prohibition is an extraordinary writ which only attaches where the actions as alleged by the order to show cause could not possibly constitute contempt. The state still has the right to have their hearing because the actions here could constitute contempt. Sheriff Young's actions, by releasing these inmates contrary to these court orders, could constitute contempt. On direct appeal, I imagine we might be back here saying, if this court was to deny the petition, arguing the sufficiency of the state's evidence as it speaks to intent and notice. And this kind of goes to the weird procedural posture of this case that you were noting to petitioner. Petitioner filed below a order or a motion to dismiss the order to show cause. And there was a hearing on the motion to dismiss the order to show cause. And that's where all this testimony came from. So the trial court's order was really just denying a motion to dismiss, saying, we're going to go forward with this.
But it went a little further than that.
It did, and it seems like the trial court may have made some, we might already know which way the trial court seems like they might come.
Well, I mean, when I read the order, I thought this was an order granting summary judgment for the state because he had made factual findings and credibility and said no one could other than understand these are clear orders of the court.
I still think that would only have spoken to the notice. If we were here on a direct appeal trying to show intent, I don't know the extent of that information might have constituted intent in this case. Now, certainly Judge Sheffield's testimony saying that he had put the sheriff on notice, hey, don't release these.
Yeah, but he put the sheriff on notice about a whole different issue, as I understand it, primarily, which was a release. The sheriff had released someone that had been under civil contempt for not paying child support, and in concert with Judge Decker, there was a determination made without Judge Sheffield's involvement that we want to allow this person to go out. There was a judge involved in that, as I understand it. Let this person out entirely. It wasn't one for 1 hour or 1 day or half a day. It was, you're out, and we're just going to make you pay $500 instead of the $5,000. Wasn't that case?
Well, the specificities of what was going on there really are only going to be used by the state at a hearing to try and show the intent here to undermine the court's authority in trying to get.
Whoa. But Judge Sheffield didn't talk about the furlough issue at any great deal. He was off the bench or back on out of Gadsden County by the time the significant problems that you're raising in your petition, alleging in your petition, arose. So I'm not sure there's much that he can contribute other than his testimony that the judiciary here is not going to issue furlough orders.
And that might be wise advice on the issue for the state in trying to prove his intent here. Maybe it wouldn't be compelling to this court, again, on a direct appeal, but certainly as it speaks to, or in this case, that there were clear court orders, those do exist in the form of bond orders. And in the civil contempt order that is at issue at this case, I'll read the specific language because there was some discussion. It said, and this was on G2, Appendix G, page 2, respondent shall be transported to and placed in the Gadsden County Jail for 5 months, 29 days. Respondent shall be permitted to purge this contempt by payment of $1,500. That was the clear court order there. And it was dictating that the terms for release in Stanley Hall's case were only to be met, or his release was only to be allowed upon serving that 5 months.
Was this the Judge Sheffield case?
This was Judge Scheffler's case, I believe. Maybe it was Sheffield. But regardless, at this point, it won't matter because what we have is an order signed by a judge saying, here are the terms for release.
Does the record as it currently stands, excuse me, we've heard a little bit at this point about discussions between the sheriff and now retired, I guess, Judge Decker about how to go about dealing with jail overcrowding. Are there any specifics in the record that is before us about those discussions? Do we know anything more than just discussions were had?
No, Your Honor, I can't recall anything in the record that's going to speak to that.
So presumably that evidence would be developed were this case to continue on?
It could be developed, Your Honor.
Because I'm assuming there would be an evidentiary hearing.
Yes, regarding the contempt in
Right,
this case.
okay.
And at that contempt hearing, the state could seek to show the intent and the notice elements that are required. Now, I want to go over to, does he have this authority otherwise? And he doesn't. A petitioner citing to statute 951.23, which he said refers to the internal operations of the jail. And certainly the sheriff and the chief jailer can oversee the internal operations of the jail. That has nothing to do with determining who comes and who goes. Perhaps what meals they're eating, what color garb they wear. The case cited by petitioner in their reply brief was Bogger v. Alachua County. That was a case where the court was looking to determine the liability in an inmate on inmate murder. And there was the court was trying to determine whether or not the county could be held liable, whether or not the sheriff could also be held liable. The county's case had been dismissed below, so the court was reviewing whether or not the county was liable. There, the court said the judge has power over the operations of the jail. And the court even went on to say that can mean determining where inmates are placed within the jail.
Oh, you said the judge has that?
Oh, sorry, the sheriff. I apologize. And that can mean determining, within the jail where inmates are placed. But nothing in that decision says the jailer has the authority to determine who comes and who goes from the jail. That's not within the internal operations of the jail. That's the judge's decision. And it's also the judge's decision, when he sets these orders, determining the conditions for release.
And isn't it also clear that the Florida Rules of Criminal Procedure are the exclusive means by which a judge may modify those orders? And there's no authority whatsoever for a sheriff to go in and modify a bail order.
Precisely, Your Honor. And that was the state's argument in its response. It was that there are all these other, when we look at the different ways in which an inmate may be released from custody, one, there is no statute authorizing Sheriff Young this exclusive authority, but when we're talking about modifying bonds, it's something that not even every judge in a criminal case may have jurisdiction over. It's only the judge, in most circumstances, who's overseeing the case, who can modify these bonds, not the sheriff. Similarly, when an inmate wants to, and he's in the county jail, wants to go into work release, this is something that the court approves. And it's not something that the sheriff even has exclusive authority over. Now, those work release statute does operate that the sheriff can consent to it and is part of the decision, but it's not exclusively his decision.
Here's where I have a little trouble is there seems to be this tension about, well, there's no statutory authority or otherwise for the furlough program by the sheriff. But then on the other side of the coin, it sounds like, according to Judge Sheffield's testimony, yeah, we'd grant furloughs, which suggests that there's authority for that, and maybe they have done it in the past, but we've decided now our sentiments are not to do it. So in my mind, there's two things going on here. The clear court order, contempt sort of process, but then there's the Article 4, executive branch, possibility of suspension from office because he's not following a statute versus he's not following a court order. We're here on the court order, but a lot of this sounds like you're operating without statutory authority or not following lawful authority out there, and that's a different proceeding. Wouldn't you agree?
Yes, and I want to go back actually to what we talked about, or what you were talking about with, it seems like we're okay with furloughs on some cases. Those are cases where the judge has granted a furlough, and some of those cases have been cited in the reply.
Well, how can a judge grant furlough if the sheriff can't effectuate it?
In this case, none of these furloughs were granted by the
right,
judge.
but go ahead. I'm not understanding how the judge can grant a furlough and tell the sheriff you can furlough this person for a few hours a day. But if the sheriff doesn't have the authorities, what's he supposed to then do?
Well, the sheriff doesn't have, and I should probably be more clear, the sheriff would not have the exclusive authority to make this decision. This decision would be something that maybe he would bring to the judge regarding whether or not and I remember when I was prosecuting in Panama City, that if there was a reason that an inmate needed to get out, we would bring it before the judge's attention.
Okay, well, here's the scenario. You've got an inmate, there's a bond, says you're not going to be released without going to Judge so-and-so. That person's mother is about to die, all right? We know she's going to die in the next few days. And they go to the judge, and the judge says, okay, you can furlough for be there in this time of need. Can the sheriff furlough that person?
He can if the court has ordered it, because then he's acting within the directives of a court order and not contrary to the directives of a court order determining the conditions for the release.
Even though there's no statutory authority?
Absolutely, because the authority comes from the court there to say, we are granting this release. He's the one who created the order, putting him into custody maybe without bond. If that judge wants to go back and say, I'm going to lift that bond for this case, he's now modifying his order.
So no judge in the circuit will grant that sort of furlough for someone whose mother's dying?
They certainly might grant that, and other judges, it may be such that if it was an emergency necessity and the judge wasn't available, maybe another acting judge or the duty judge might call that judge and say, are you okay with me signing this order? But we don't even have those factual circumstances in this case, so we don't have to worry about it at this point.
I understand. I think we all understand that there's been some serious ramifications of some of these furloughs. I totally get that.
Absolutely, and I think those serious ramifications can be the sheriff can be held accountable for them through the vessel of contempt of court, because the clear court orders in this case directed the sheriff at the conditions of release of these inmates, and because he disobeyed these orders, the court should deny this.
Well, if I could ask you before you sit down, hope springs eternal. At least at one point, the sheriff sat down with Judge Sheffield and they worked things out and everything worked fine. Are we beyond hope springs eternal here, or is this, are we just going to roll the dice?
Your Honor, I don't know that I have an answer to that question because I'm not going to be the one handling the case going forward. However, I think Sheriff Young's actions certainly here were egregious when you have these clear court orders that he was disregarding and essentially letting these dangerous inmates out onto the streets. And in one case, the Stanley Hall case, we know that worked out very poorly for the victim of a battery that he committed while he was out, contrary to the court orders. And so I think going forward, the state may still want to proceed it, would definitely still want to proceed on it. And for these reasons, this court should deny.
Counsel, I have a question for you as well. The sheriff has pointed to the Department of Corrections furlough policy and the circumstances under which furlough may be granted with the department. Are any of the cases that are before the circuit court, would they have qualified for furlough even had the department's policy been available for the sheriff?
That's a good question. I don't know that I have the answer to that because of the depth of cases. I can only think about the most egregious defendants who certainly wouldn't have qualified for it.
Oh, but I'm sorry to interrupt, but there's testimony from one of your witnesses that said each and every one of the 20 would not be.
Okay,
eligible.
and we can rely on that testimony then to bolster that argument. For these reasons, we should deny the petition. Thank you very much.
Thank you, counsel.
Sorry for interrupting.
Your Honors, in its argument, the state, through the Office of the Attorney General, now takes the position that a furlough is equivalent, for legal purposes, to a release. And I'd like to point out that is a 180-degree departure and change of course from prior legal positions taken by the Office of the Attorney General. In this court, in the Price case, which is cited in the pleadings, this court ruled at the behest of argument from the Office of the Attorney General that an inmate was in custody for escape purposes while he was on an unescorted furlough. In the Second District Court, the Second District ruled that an inmate was in custody for sentencing enhancement purposes while he was on an unescorted furlough. For the first time this afternoon, the state now takes the position that these first appearance orders, which are nonspecific as to furloughs, violate the conditions of a bond imposed by a circuit court judge because they're equal to a release. And I would submit to you that that is diametrically opposed to what has been argued previously.
I didn't quite hear that. Could you explain that? They're saying it's equivalent to a release?
Yes, a furlough, my position is a furlough is not equivalent to a release.
Well, I heard that releases are different, but there's inherent judicial authority to authorize a furlough.
Yes, sir, I agree.
That's what I heard.
Yes, sir. Yeah, and I don't take exception to that. I believe there is inherent judicial authority to authorize a furlough. But I want to point out that the record in this case establishes that furloughs were, as I've said before, they were undertaken by the prior sheriff. They're undertaken by the Department of Corrections, absent a court order, and they've been recognized in this court's jurisprudence in the Price case. And Judge Martzler, I want to address earlier, I don't know if I answered your earlier question, all it would take is one court order that would prohibit or limit furloughs. I didn't want to leave the court under the impression that I was of the position that a court order addressing furloughs would be required in every case. In this case, the state has sought indirect criminal contempt sanctions without having first obtained a clear court order as required. For that reason, I would encourage the court to grant the requested writ. Thank you.
Thank you, counsel. Thank you both. That concludes our docket for today. We will stand in recess.